I'm going to run through a few things here. So it come back, the order from the judge, where the judge has actually said the defendant's strikeout is dismissed and blah, blah. It goes through the thing. So basically she's saying you won. And this is what I want you to do. The things that she wanted to do was she wanted me to put that at the head of the claim, amended particulars of claim under CPR rule 17.12a dated 14th of May. She'd done it exactly as she wanted it seen. We then added Police Sergeant Jacob Fuller. The other side had written some, if I showed you it, you'd realise how childish it was. And they put it in and says, as incorrectly sued. The judge agreed there was no incorrectly suing because we only had his number and his number was there. So we had no name and then his number. That's not incorrectly suing him. That is the police and the police solicitors obstructing justice by not giving out his details. In other words, his name. All they do is look the number up. Was that you? Yes, it is. There's the details. That's what you need to put on the order. They hadn't done that. And they'd crossed it out and said, not the correct person to sue or whatever. It was bullshit. And the judge actually agreed because what I put in was that, only that, and the judge come back with exactly what we wanted. So there's other elements to this. At the end of the document, you must have, and this is what the judge wanted. So there's a slight change from what we had written as the statement of truth, as written in a book by a judge, because they changed the CPR rules in between. They understood that and said, "What? This is now the current one. You need to use this." So it says, statement of truth, I, Charles Staple, believe that the facts stated in this witness statement are true. I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without honest belief in its truth. And there it says, Charles Staples, a plumber, 14th of the 5th, because that's what it had to be in, boy, it's been signed for that date. So this all comes into effect on the 14th with assistance of a book, Pleadings Without Tears. Again, it was a High Court judge that wrote that book. There isn't any changes in it other than an emphasis on what we've discussed for the last two nights. So what I want to do is show you, the people, what has been put in this claim. There is a case conference in September. There's a lot of work to be done beforehand, including a skeleton argument that highlights each area, which is what we're going to be doing, and conveying to them that if any of these are proven, the constables have perjured their oath. Not perjury in law, perjury in fact. And they're two different things. So special damages, aggravating and exemplary, and vindicatory damages. So you want to be vindicated, but you also, for your injuries and for your emotional distress, some people call it hurty feelings. It's a bit more than that, I can tell you. You need to be compensated. Those damages are aggravated, and become exemplary. And this is a legal term, acting in an oppressive, arbitrary, or unconstitutional way. So the defendant's actions characterized by oppression, arbitrariness, and disregard for constitutional rights and English Convention rights from an English Convention Parliament, UN rights, UNCAT, and the European Convention on Human Rights, all of these are incorporated into domestic law, have caused the claimant significant harm, both physical pain and psychologically. So the oath system, and this is the bit that's really important. So I want people to concentrate on what I'm saying, because this is the bit that if any one of those claims are admitted, and they must be admitted by all five police constables, they have perjured their oath, and therefore they could no longer be police constables. That is the essence of why this is in there. And it is aggravating damages. And I can go back and show you the last night's reference to that. But here goes, right? The oath system, deeply embedded within English law and custom, continues to uphold ancient usages crucial to the integrity and functionality of legal and public duties, as historical and legal precedents set forth by esteemed jurists like De Bracton, Sir Edward Coke, and Lord John Somers illustrate. The oath is a binding tradition that ensures accountability and ethical conduct in various offices, from police constables to judges. The necessity of the oath for police constables who must swear or affirm before receiving a warrant card parallels other significant oaths such as the coronation oath, Privy Council oath, the MP's oath, and the judicial oath. These oaths collectively mandate a solemn commitment to uphold the law and customs, reinforcing the roles of ancient practices in contemporary governance. The breach of such oaths, particularly through perjury, and I mean perjury in fact, and the perjury of an oath by police constables, constitutes not only a violation of legal duty, but also an aggravating circumstance warranting exemplary and vindicatory damages. So you want vindication, you also want compensation, and you also want punitive damages to stop them doing it to someone else. That means there's public interest. That means there should be a jury. This is underscored by the fact that without the oath, the individual is deemed unfit to perform their role, akin to how, without historical adherence to these practices, the modern legal system would falter in maintaining public trust and legal integrity. In other words, if everyone decided they weren't going to obey their oath tomorrow, you wouldn't have a legal system, you wouldn't have a country, you wouldn't have any functioning constitutional elements whatsoever, which is part of the problem. So the whole paragraph needed to emphasize the importance, because what they try and do in many cases is they will try and get out the exemplary and aggravating damages, and then you're left with a massive legal bill and they'll pay you 20 quid. That's not the way this works, and especially under the oath system. And I've said to Charlie, don't forget, you are literally Charlie versus the British Goliath. They're certainly not going to want to admit any of these things, and it leaves you in a pretty naughty position. Charlie is absolutely vehement that he wants this 100% to go ahead. I've explained it. He's not stupid, by the way. And hopefully we've got this case hearing now in September. I've got to look the date up. We're then going to take it from there. So all of the information is in there. The case is set out exactly as the judge wanted. There does need to be some other elements. I need to speak to Wills, or Charlie needs to speak to Wills from GB Resistance, that if any others who watched that video have got video recordings or was there, we need them to come forward. One, to give us the video recordings, and two, potentially to give live evidence. And again, we'll take statements, and the statements will be presented in court. They may take them as read, which means you haven't got to give evidence in chief. They may call you to give evidence. Hopefully, Charlie will speak to Wills, or I'll try and ring Wills when I remember to. I've got a million things on my mind.